Hey everyone, welcome back to the channel. Today we are diving into an interesting area of Singapore law, the tort of unlawful interference with trade. This tort is a powerful tool for businesses facing malicious interference from competitors or third parties. So let's break down what it means, some examples, and the remedies available. Now, unlawful interference with trade occurs when someone unlawfully interferes with another party's business or contractual relationships. The main goal of this tort is to protect businesses from unfair competition or malicious acts aimed at disrupting their commercial activities. To establish a claim for wrongful interference with trade, 4 key elements must be proven. Number 1, there must be an unlawful act. This could be an illegal act or a breach of statute. Number 2, intent to cause harm. The defendant must have intended to harm the claimant's businesses. Number 3, interference with the claimant's trade. The unlawful act must result in interference with the claimant's business activities. Number 4, causation and damage. The unlawful act must have caused actual loss or damage to the claimant. Unlike the tort of inducing breach of contract, this tort is not primarily concerned with the protection of pre-existing legal obligations, but with prescribing indirect harm inflicted through the use of unlawful means on an intermediary. The mental requirement of this tort appears to be a narrow one. The defendant must have intended to injure the victim as an end in itself or as a means to an end. The fact that the defendant's unlawful conduct would inevitably injure the victim is not by itself sufficient. Since the House of Lords decision in OBG and Allen, it is reasonably clear that the illegality must have been applied to a third party with the result of causing damage to the plaintiff. However, it is unclear whether the illegality must also be separately actionable as a civil wrong. The alternative view is that any legal wrong is sufficient, even one that is not independently actionable, so long as it causes the victim's loss. A number of authorities from other leading jurisdictions have adopted the former view that unlawful means should be restricted to independently actionable wrongs. The Court of Appeal in Singapore has adopted the broader view in the case of EFT Holdings. So what remedies are available if you are a victim of unlawful interference with trade? In Singapore, you can seek compensation for the losses suffered due to the unlawful interference, or an injunction to prevent the defendant from continuing their unlawful conduct, and even an order for the defendant to hand over any profits they made as a result of their unlawful act. So, the tort of unlawful interference with trade can be a powerful remedy if your business is under attack by competitors or malicious third parties. By proving intent and damage, you can seek compensation and even prevent future interference. That's all for today, folks. Until next time, stay informed and protect your business. See you in the next video.